So our next panel is on the current issues in insolvency and liquidation, certainly switching gears a little bit from where we were. Amy Kalal is the moderator, and she's a partner at Mound, Cotton, Woolen, and Greengrass, my partner, and has nearly 15 years of experience in all aspects of complex reinsurance litigation and arbitration, as well as third-party direct insurance coverage disputes. Her practice includes coverage and defense on behalf of ceding companies and assuming reinsurers with respect to legacy asbestos and environmental liabilities and other runoff business. She has arbitrated dozens of cases to final award and has also litigated cases in numerous states and federal courts. Keith Kaplan leads Reliance's reinsurance operations, including related accounting, finance, and claim functions. Keith was one of AROC's founding board members and served on their board through 2014. He is a certified arbitrator by Arias US and has been a speaker at various industry conferences, corporations, and universities. Mr. Frank Kerwald is a senior vice president with Swiss Re Global Litigation, Reinsurance, Asset, and Liability Management. He has 35 years of insurance and reinsurance industry experience, including legal, claims, and underwriting. He was general counsel and director for 8 years for all aspects of primary property casualty insurance and separately America's reinsurance operations. He is a dispute resolution attorney concerning disputed claims, mediations, litigation, and arbitrations, and counsel to the reinsurance commutations team. Myra LaBelle is a managing director in the New York office of Guy Carpenter & Company, where she is a member of the Strategic Advisory Group and advises clients regarding reinsurance and insurance legal and regulatory issues, reinsurance contracts, and impact on clients' companies and mergers and acquisitions. She negotiates with reinsurance markets on a variety of issues relating to reinsurance collateralization and contracts. She has spoken at numerous industry events as a presenter and company representative at seminars on insurance regulatory matters and reinsurance contract, including the IRU, where I think we both just spoke together within the past, month or so. That was a lot of fun. And at an organization, also at HB, the American Bar Association, and others. She was formerly vice president at Zurich, and she began her career as an attorney at Mound Cotton. So with that.
And I knew Lloyd when he was a whippersnapper.
So as Lloyd's introduction indicated, we've got a tremendously experienced panel here who is going to speak to a variety of issues from very different perspectives. First, we're going to start by talking about the differences between rehabilitation and insolvency and how a company becomes insolvent and what happens in the early stages of insolvency once a liquidation order has been issued. And we're also going to discuss some of the major differences between insolvency in the United States and in the UK, and touch on solvent schemes of arrangement and the attempt by a couple states in the United States to implement that. And the next topic that we're going to include is a variety of claim handling issues, such as claims estimation, the role of guarantee funds, claim reserving. Then we're going to touch on probably the most important and will engender the most spirited debate of the panel is the reinsurance issues targeted from specific language in the reinsurance contracts, such as notice provisions, offset, and the role of intermediaries, audits as well. And then finally, the panel is going to discuss, and I hope we get time at the end, a little bit of the commercial ways that estates can be wound up, and then a few of the current issues facing, insolvency practitioners today, including collateralization and regulatory oversight. And with that, I will turn it over to the panel, and I believe Keith is going to start with some of the basics.
Could I just make one little disclaimer on my part, what I call the heart attack disclaimer, because our corporate compliance counsel just walked in the door from Guy Carpenter. And so I just want to state that these are my opinions only, and also that Guy Carpenter is the most conscientious and excellent reinsurance intermediary in the world.
Noted.
Noted.
Okay, and actually, I have to echo that disclaimer as well, among other reasons my boss is here. But in my case, it includes the Pennsylvania Insurance Department as well as people who I'm not officially speaking for today. And so these are my opinions. In some cases, they're not even my own opinions. I just say them to spark controversy. But in any event, I don't want to spend a whole lot of time on this early part of just giving you some of the basics. And we're talking about rehab and liquidation. But it really starts before that. When companies start getting in trouble, the first thing that happens is what I call quiet supervision, where the insurance department starts taking a little more active interest in what you're up to, and you may negotiate a little letter agreement with them. So, and certain things have to get approved by them, like Keith Kaplan getting promoted or something like that. And then it moves on to public supervision. An official order gets issued, and an on-site supervisor shows up and is looking over your shoulder at certain transactions. And different states will handle things differently. In some states take an approach of going through a long, protracted supervision, including supervision of a runoff process, even though they know it's going to end up in a receivership in the end. Other states put people into receivership fairly quickly, and the difference, obviously, is in one case a lot of claims get settled, along the way, and a smaller pool of claims end up in a receivership, but also less assets go there. If you get it in sooner, a lot of the assets are there as well, and people get treated probably a little more equally. But anyway, if all that supervision fails, the fun part starts with rehabilitation. When the insurance department gets a rehabilitation order, and you come into work one day and you're greeted with a whole team of people saying, "We're here to help." And the goal of rehabilitation really is to develop a plan to return the company to viability. And I think what's most significant about the rehabilitation process is that the rehabilitator has very broad powers, has a lot of discretion, lots of flexibility in how they go about that. And on the slide is some of the rehabilitative steps, various limitations that may be put in place, which includes restricting investments, liquidating investments, prohibiting the writing of business, handling claims a certain way, and suspending dividends, and even limiting the amount of offsets that reinsurers are allowed to take, as an example. Now, one of the things I will point out, and I haven't really, to be honest, I haven't studied this statistically, but my observation over many, many years is rehabilitation is rarely successful. Usually it's just a waypoint before you get to liquidation. But I will say Pennsylvania does boast 2 successful rehabilitations along the way, Mutual Fire and Fidelity Life. And they're currently struggling with a company in rehabilitation. It's a long-term care provider. But anyway, the fun stuff, liquidation. In contrast to the flexibility of rehabilitation, liquidation is governed by statute. So there's rules to follow. And the primary goal is maximize the assets, determine the liabilities, and distribute the assets. But I wanted to give you a little practical side of what happens in a liquidation. The first, very early on, as I said, the government shows up, and when they show up, they take control of the offices, equipment, all the records, the assets. Literally, where are the keys to this? They're not yours anymore; they're mine. And they decide who they want around and who they don't. Then the real process starts. A lot of notices get sent out. In Reliance's case, I want to say it was like in the millions. I might get a correction back there, but it was a lot of notices get sent out to alert people to it. Claim files have to be reshuffled. In the case of Reliance, we had the claim files were sitting at various branch locations around the United States, as well as at various third-party administrators who handled accounts. And they had to get those to the appropriate guarantee associations, who I'll talk about more later on. But those claim files get shuffled, get sent over to the guarantee associations, who in turn, the first thing they're doing is looking at, is this really mine? And then they'll send it to the ones that were misdirected, sent to the right place. Very importantly, POC, proof of claim forms, get sent out to potential claim holders. So different lists of potential claim holders exist. They'll go to former employees, they'll go to reinsurers, they'll go to policyholders and claimants, brokers as well. In fact, I think Swiss Re filed a claim in the estate for like a couple $2 billion. They examine what other sources of potential liability may be there and file some lawsuits, attempt to claw back assets that fell where payments were made within the preference period. So that's all going on very early. What I call the mid-stage, that's the part that takes like years. That's where claims are being settled, notices of valuation are being issued, reinsurers are being billed, and money's being collected. Commutations might start. When money starts rolling in and you have enough interim distributions will start taking place, early access to guarantee associations. And then eventually you get to the late stage. And we'll talk more about that later, but it involves getting a bar date, which is an absolute cutoff, making final claim settlements, putting out a final accounting, and making final distribution. So that's the Reader's Digest ABC version of liquidation.
Thanks. I guess now. Okay, go
I have
ahead.
a couple comments, Keith. First, I have to make the same disclaimer. I'm not speaking for the company, but Keith and I both sat on the board at AROC, and my first observation is rehab and liquidation and receivership, in many respects, are a statutory forced exit plan for the insurance industry, and in particular, insurance companies that are experiencing financial difficulty. But in the broader picture, it's an answer to issues that many companies, even going concerns, deal with. Is our industry has had a very oversighted view of exit strategies. Many companies write property policies and auto policies are fairly short term. And the flip side is many companies have issued GL policies and comp policies that the issue is the coverage continues forever, as Robert commented in his group presentation. Insurers and reinsurers have dealt with property ag because we've had to, right? The hurricanes and winds have forced companies to put a dollar cap on matching liability so that we can all stay financially afloat. The flip side is the GL industry has been issuing lifetime, well, forever, coverage on GL and comp obligations, comp being limited to lifetimes. And we haven't done a very good job of exit strategy plans. And in some respects, that's why our trade group, AROC, exists. That is, collectively, we try to get together and settle up balances. But we also try to settle up balances both to keep groups and companies solvent, but to use our capital more wisely. Keith commented on the structures of receiverships and rehab. And he commented earlier when he and I were speaking, many of these transactions and disputes are different depending on the personalities you're dealing with. And the same rule applies to receiverships, rehab, and liquidations. Even though there's a statutory formula for how to proceed in terms of some particular outline and rules to deal with the estates, how individual estates are dealing with issues is hugely different. And a perfect example, he commented on the rehabilitation of mutual fire, and obviously some of us would say, well, that came at some expense. Similarly, right, Pennsylvania has more recently been very adept at dealing with an exit strategy. That is getting involved in the estate, setting together a plan, accumulating the information, accumulating the plans, and then putting together a outline of how are we going to get out of this receivership? How are we going to get out of this liquidation? And that's my point. In the big picture, receiverships, rehab, and liquidations are an exit strategy for financially troubled companies.
Just on that note, there are other exit strategies that are available. Within Guy Carpenter, we have a group that deals with lost portfolio transfers and adverse development covers. But there's also, in the industry, a lot of interest in what the UK has pioneered and worked through very successfully, which is solvent scheme of arrangements. And there's been several attempts in the US to try and duplicate that, most notably in Rhode Island, where they've recently amended their solvent scheme of arrangement law. Because one, in my viewpoint, one of the flaws in the US attempts to duplicate solvent schemes of arrangement is that you have Rhode Island deciding that they're going to run off or put into a scheme of arrangement a company that has policyholders in other states. And until you can assure some sort of finality, judicial finality, legal finality, that will satisfy all those other state insurance commissioners, you're going to be subject to non-finality, which when we work on lost portfolio transfers and adverse development covers, finality is an important part of the equation. So I think Rhode Island has recently included a judicial review and a judicial order that has to be part of the solvent scheme of arrangement.
And in the same vein, I think the industry is tremendously excited about the Rhode Island statute in terms of having at least an initial framework for a exit strategy similar to a Part 7 in the UK, which establishes some finality. Obviously, the issue is the finality in Rhode Island is so far as certain as Rhode Island law, and right, hopefully it will become more broadly accepted. But that's the huge advantage of the UK Part 7, is it's been tried, tested, and confirmed. It's been widely enforced around the world, and it has been a excellent method for people to get a ring fence around liabilities that need to be ring fenced, and it allows companies and groups to isolate portfolios, deal with them, and move on and continue to write new risks.
I think you had a statistic in here that UK Part 7s are 10%, recover 10% more in recoverables than the U.S.
My own experience is dealing with liquidations. That is one of the observations about liquidations in the U.S. versus liquidations in the U.K. and other regulated locations is that one would expect, because the states in the U.S. spend a great deal of time examining companies and focusing on audited financial statements, that when receiverships or liquidations happen in the U.S., the recoveries for policyholders and or claimants you would think might be higher in the U.S. than in other locations. But honestly, my personal work experience has been that in environments where the reporting requirement is self-reporting, Bermuda and the UK, although the UK is much like the U.S. in terms of audits and heavily regulated, recoveries in other parts of the world in liquidation are higher, and it somewhat defies common expectation, but that has been our experience. It is in liquidations, payouts in Bermuda and other parts of the world. Who knows? Maybe it's just the factual circumstances of the estates, but on average, those recoveries are slightly higher. In some estates in the U.S., the payouts are higher, but on average, payouts in the U.S. are to general creditors are not generally hugely material.
As far as the expense of receivership and running off the insolvent estate, it's a shorter time period in the UK, so that's going to be naturally lead to less expenses.
Which raises an interesting discussion about why has there not been an acceptance in the U.S. market of an exit strategy or setting up of an exit plan? And on that same vein, the NAIC dealt with that issue some. It has enacted a model insolvency statute, unfortunately, which has not been adopted in any location, which provided for an exit strategy. It had a 3-year time period on short-term liabilities and an 8-year time period on long-tail liabilities. And that's the real issue. That is, the financial marketplace, including reinsurers, need to have some reasonable certainty in order to wrap up the financial obligations. On long-term liabilities, if a company was writing for 1 year or 2 years, it has no meaningful track record to estimate future liabilities. And that's why some time period is required for the development of losses so that reinsurers and the industry can develop a plan to wrap up estates. And granted, the process works more quickly in the UK, but the whole issue is, can those liabilities be reasonably predicted?
Mm-hmm. Have either of you had any experience with the New York regulation, 141, the commutation regulation, or seen that used successfully? Because I have not. Or was anybody in the audience? I know Jim Veach used to talk about that.
I've seen it used in several estates. It's not unused, as there have been several New York companies that have gone through a New York 141 exit plan. Again, it works well when the liabilities can be reasonably estimated, and much like a Part 7, the plan is brought to the court. Creditors have an opportunity to voice a view, and then it's endorsed by the department and enforced by the court.
I saw a hand back there. You've seen one as well?
I was involved in a two-way commutation. There was an inwards and outwards relationship. And it was a difficult process trying to get the same valuation used on both sides.
Oh, interesting.
Also, the timing of the liabilities was a bit of a problem because obviously you have a distressed company that's trying to take advantage of the 141, and their records are, 5, 6, 7 years out of date. So, it's not without its issues or problems, but the reality is, we would not have gotten offset without doing the deal. So, I think it was the best that could have happened in those circumstances, dealing with that company.
Sue, what role does the New York department play in that?
Well, first of all, as you said, the proposal needs to go to them. They
Right.
the parameters of what the payout will be and what the construct of the deal, the commutation deals will be, based on the financials that are presented to the department. Now, all of the other co-parties, you don't get to participate in that process. So you're just sort of given a rubber stamp proposal saying, well, this is what New York has agreed to, this is what they will allow, and so here's your share of that. So, that they're involved very much up front. They also had to approve any deviations in the standard wording on the commutation agreements, and because I was pushing for this ceded assumed deal and offset, they needed to be involved in that. And so for the valuation of our financials, a consultant was brought in to give the department an opinion on the
Interesting. Thank you.
If I could just jump in so we can,
Oh,
in the
sure,
interest of
sorry.
time, could we just turn now to some claims handling issues, and we'll start with the role of guarantee funds?
Okay, so it's back to me. Guarantee funds are triggered by a declaration of insolvency. They handle claims up to their limits, which in most cases is $300,000 for the liability claims. A couple of states it's more than that. I think the key is they don't cover everything. In about half, actually I think it's 30 states, there's net worth exceptions. So insureds whose net worth are over a certain amount aren't covered by the Guarantee Association. Now, having said that, I think at least half of those will still handle those claims, and then they just bill it back to the insureds themselves. There's issues in terms of how deductibles apply. They'll settle the claim, and then they look to the receiver to go bill the deductible, at least in Pennsylvania. And so we have to do the work of billing and reimbursing them. Going back to the exclusions, beyond net worth, financial guarantees not covered, mortgage guarantees not covered, sureties not covered, reinsurance isn't covered. And in those cases, it's all because they're lower priority classes anyway. Surplus lines falls outside of guarantee fund coverage. And the other thing to point out about guarantee funds, there's different kinds. There's the property and liability funds. In some states, property, liability, and comp is one fund. Some states have separate funds for work comp. There's separate funds for life and health. So, for example, in a state like Pennsylvania, there's actually 3 guarantee funds. There's one for property and liability, there's one for work comp, and there's one for life and health. I think on the slide they talk about the assessments. How are they funded? There's assessments that go out to the insurance companies, so they take a percentage of the premium to help fund the guarantee funds. And the other place they get money is from the insolvent estates themselves. Their administrative expenses are our administrative expenses. So their costs of administering the claims, get paid. And as we raise money, they get distributions as well. And there's provisions that allow them to get money ahead of other people. It's called early access, and it comes with clawback provisions, so you're not put in the position of having to overpay them. And actually, once asked some of the guarantee funds, has that ever happened? And they said, yeah, actually it has, and yes, they do have had to pay it back to some estates. I
just have a quick comment on guarantee funds. Right, in the big picture, for admitted companies, right, their marketing selling point is, hey, at least you get some minimum coverage for doing business with an admitted company, and the benefit is, of course, your claims get handled by the guarantee fund, and your injured parties get that financial payment. The disadvantage from the big picture is that now you've got 50 states handling individual policyholder claims, handling them differently, handling them on different financial systems. And in terms of wrapping up the estate or bringing any finality, you've now added a couple years for them to get the policies, get them sorted, get them on their system, deal with the claims, and get that information back to the estate so that the issue of wrapping up the estate can move forward. Obviously, for longer tail claims, that process continues for years and years and years.
Yeah, and just to, Frank makes a good point. Earlier on, I talked about, sending, thousands of and actually literally tens and hundreds of thousands of files off to guarantee associations. It does take a while for them to get online, and then, they have their data systems, which at least is a common system, and then to get that linked up with the receiver is kind of an important process. So there's actually a lag of information reporting coming in that creates a lag going back out to the reinsurer. So just by virtue of the Guarantee Association process, the company in liquidation is almost analogous to a reinsurer itself, because it's relying on somebody else for the information to come in, and their reserving practices are all over the board. From the extremes of only reserving for what they think they're going to pay out in the next couple of years to at the other extreme, worst case scenario estimates. So it's important, for, best practice amongst, receiver would be to go out and make sure that you're on top of those files. You do claim reviews, of the guarantee fund claims, not in a traditional audit sense, really just to make sure that you can standardize the reserving across the board and then just do like an overlay of their reserving. Not to mention which, as I said, there's caps in there, so a lot of these claims are going to bounce into the estate beyond the guarantee association part anyway. So that's all part of what goes on. But once the information starts flowing and you're getting out there, then it does return to normalcy, in terms of getting the information to reinsurers.
Of course, the last piece of the puzzle is when it comes time to put together an exit strategy on that portfolio. And obviously, one of the opportunities for reinsurers, for example, is to commute a whole estate in a single commutation. And we're able to do that sometimes when the book is quite mature. In the case of Reliance and Legion, these estates were so large to us, in the hundreds of millions of dollars, that we had to isolate portfolios of business, price them individually. So the last piece of the puzzle is that these guaranteed policies are reinsured. And I don't know the process for that recovery getting back to the guarantee funds. But putting together the exit strategy, we're dealing with a portfolio of business, be it Reliance business or others. We put together a commutation plan with respect to the estate, but some communication obviously goes on between the estate and the guarantee funds in terms of agreeing to the final reinsurance payout and getting some of the money back to the guarantee funds.
Well, they're just another, we have a comment from the audience.
Just a commentary to make sure that everyone understands. For workers' comp, that line of business for almost all GAs is covered 100%, so that they pay all losses and expenses related to that line. That's, the golden cow, can't be touched, et cetera. And the limits of the liability, he said, obviously, if you write large limits, some of these liability lines have very large losses, and anything over their limit of 300,000 or so will come back to the estate and have to be evaluated on a separate basis and then evaluated for reinsurance.
I just want to, to the extent Frank doesn't kick me under the table, I just want to add what the actual story was with Swiss Re. Swiss Re on its own was one of our largest reinsurers. Employers Re on its own was one of our largest reinsurers. You put the two together, they were our largest reinsurers. You're talking about tens of thousands of contracts, over $1 billion of liabilities being ceded to them. And I had this pie in the sky idea in late 2006, early 2007, where I dealt with a couple levels up the chain of command at Swiss Re, who also had a lofty idea. Let's just do one big global deal, and just get this done and get this off our books. We'll get a lot of cash. And we actually started that process, or our respective staffs did. And then there was points where people started coming to me and said, this is just too much. You can't. There's no way. And meanwhile, same thing was going on in the Swiss Re organization. So the guy I set this up with, we run into each other at a conference, and he just looks at me and says, this ain't happening. And then we went to Plan B, which is you break it into the manageable chunks, and over time you get it done. And we did.
But as Keith said, this was one of our largest financial obligations. So when the liquidation happened, and it happened fairly suddenly, as those of you might recall, there's a million details that are not resolved, right? The whole issue of what's happened to the premium, what's going to happen to the commissions, those policies that are excess policies, comp. So while we had the dream of doing a simple, quick, efficient discount and payment, the practicalities of quantifying that on any individual segment just proved too daunting. We were not able to do a single transaction. But the good news is, fairly efficiently, we were able to look at portfolios, starting with the more developed portfolios, and committed them one at a time in blocks of 50 or 100 million, such that that $1 billion of liability is now well under 50 million, and in a fairly short period of time. So again, my observation with the Pennsylvania Department in handling liquidations, and some other departments have gotten much more astute, including New York and Illinois. When there is a focus on expediting the estate, maximizing the reinsurance recoveries, marshaling those assets and get them into the estate, that process has worked amazingly efficiently, although granted, not in a single transaction.
Thanks. If we could just turn now to the relationship with reinsurers and, view through the lens of some specific contract wording. We'll start with the insolvency clause.
Okay, did you want to, I just want to say a word about claims estimation, which
Absolutely.
is a very, very hot topic. And my perspective is usually before the insolvency happens in structuring deals for companies that are in financial distress or traditional contract language. And there has been a battle about the concept of claims estimation, which relates to long-tail claims and the ability of a receiver to estimate, based on actuarial analysis, what the claim's final collection would be, and bill reinsurers for that. And naturally, reinsurers are not keen on agreeing to a receiver's estimation of a claim. And in fact, there are only a finite number of states that have this included in their statutes as expressly allowing a receiver to do such claims estimation. So from my perspective, how this is played out is that we have a battle in the contract wording in the insolvency clause as to whether the receiver can collect without diminution, which is the traditional language of the insolvency clause in reinsurance contracts, based on estimation of claims. And we only put this in contracts where it is in the statute. And so reinsurers feel a little protected, at least contractually, that they can point to this language if it doesn't exist in the contract and say to the receiver, you can't collect on that basis. Sorry, did someone want to make?
No, I would make a couple observations. That is, this language without diminution arose out of the pink liquidation in the 30s. So that language has been mandatory in reinsurance agreements in New York, approaching 100 years. But the issue with respect to claim estimation is timing. And the issue is entirely predictability. As I said, if you have an estate for a company that was only writing business shortly, it's very difficult for both the cedent and the reinsurers to agree on an estimation of how are those liabilities going to pay out. So while in general, there has been this very heated discussion of claim estimation, it all centers on the reasonability of estimating those liabilities and accelerating payments. The reality is, commercially, people want to estimate those losses and get on with business and spend the energy on things other than handling these claims and liquidation, as long as those claims can be reasonably estimated.
Reasonably, that word is so elastic. As the New Yorker cartoon showed in the last panel discussion. So, for example, the Reinsurance Association of America does not find it reasonable that a reinsurer's, that the liquidator of a ceding company can make claims estimations without input from the reinsurer. So that's the battle lines that are being drawn. As part of that insolvency clause, there are other features. There's the right of the reinsurer to notice of the liquidation and of specific claims that are going to be adjusted and quantified, and the right to dispute them, the right to a defense, and that right exists separately for each reinsurer.
And obviously, the reinsurer's observation is this is a very important right. That is, the company goes into liquidation, we're not hearing things for months, sometimes years, and suddenly you get a bill from the estate for, who knows, right, $50 million. We didn't have those liabilities on our books, as we had no notice of these claims. So on the one hand, we understand the difficulties in the practical day-to-day administration issues of the estate, but for reinsurers, this notice requirement and the opportunity to intervene in major losses is a very material right.
So Frank, how often have you intervened in
Obviously, this is fact and claim driven, but the fact that we're able to develop an exit strategy for estates, and again, Pennsylvania, we had both the Legion estate, which is 500, 600, 700 million, and the Reliance estate in excess of $1 billion. We were able to collectively work together and establish this exit strategy. But with respect to individual claims, I agree with you. It is much more difficult for reinsurers to intervene on any individual specific claim situation.
So the reinsurance contract that was negotiated by the parties 1 to 10, 15 years prior, especially in the case of long-tail claims, is still in place. The receiver cannot abrogate that contract. They only step into the shoes of the insolvent. In this case, we're talking about an insolvent seeding company as an example. So they take that contract with all of its provisions, including, I might add, the notice of settlement and notice of loss provisions, which is a hard provision to enforce when the reinsurance contract is between solvent parties. So I would assume it's also hard to enforce against the receiver because of circumstance and because of the rather flexible language in the notice of loss settlements clause. But there are also inspection and audit clauses so that the reinsurer should have the right to, in some cases, even coordinate on defense of a claim and audit the appropriate claims files. I assume there's a lot of difficulty with that, with enforcing that right as well, as discussed. I'll just run through a couple of the other clauses, right. And if you have a war story, you can feel free to jump in. There's also another clause that very few people focus on, which is called a multiple cedents clause. It's usually embedded in the preamble of the contract, and it became important because the NAIC started requiring that when there are multiple cedents on a contract, there be some sort of allocation agreement as to how premium and losses were going to be distributed. And this becomes very important in the insolvency context because if one of the multiple seeding companies on the contract is offshore, a New York regulator, for example, that supervises a seeding company domiciled in New York with an offshore affiliate does not want claims and premium to be moved around out of its control, out of the New York receiver's control. So there's a clause that very few people focus on that is rather new to contracts, which states that each party to this contract is going to be treated separately as, per the preamble. They you shall not be, balances recoverable are not going to be allowed to be offset between the parties. There has to be an allocation agreement in place pre-existing. Another major part of the insolvency clause is usually a reference to cut-through rights. It's usually by reference to New York law, but there are cut-through rights embedded in most of the state's law. And a cut-through exists when the ceding insurer usually needs the benefit of a higher or more stable financial rating than it has, and so that it can ensure, in the case, for example, of a mortgagee, that the financial rating of its reinsurer will be available. Should the ceding company go insolvent, the insured and its bank can cut through directly to the reinsurer and get the reinsurance proceeds directly from that reinsurer without having to go through the receiver. And naturally, this is not something that is looked upon with great attractiveness by receivers, and from time to time, we get pushback from state insurance departments. I believe Pennsylvania sometimes has objected to cut-through language in reinsurance contracts, which is a little bit odd because there is a very famous Pennsylvania case, I believe it's called Kochen v. Legion, in which the Pennsylvania courts allowed cut-through directly from a reinsurer to a ceding company, even though there was absolutely no cut-through language in the reinsurance agreement. And the circumstances of that was that the ceding company was actually a fronting company, and the reinsurer was the actual party at risk, handling claims, dispensing proceeds, so that there was some basis for that. But usually, to enforce a cut-through, you need not only a reference in the insolvency clause, but you also need a clause called the alternate payee, in which you identify that there will be a requirement on the part of the reinsurer to pay another payee in the case of insolvency.
Yeah, so the regulatory structure is that the state liquidation statute allows for, typically, cut-throughs in the event that the cedent and the reinsurer have mutually agreed in advance to the cut-through. Hence, in the reinsurance agreement, the cut-through language exists in the insolvency clause if the parties have agreed to a cut-through specifically with respect to that reinsurance agreement. The difference in the Kochen case is that the Pennsylvania court enforced a cut-through when no cut-through clause had been bargained for, paid for, or negotiated. And for the claimants against the estate, the issue is that has the suggestion of being a preferential payment, of 100% payment to certain creditors versus a lesser payout under the liquidation program to liquidation creditors. One can understand the nature of the cut-through in Legion. These were MGA-administered programs that Legion wasn't administering whatsoever. The obligation was 100% reinsurance to the reinsurer. So emotionally, I can understand the Kochen decision, but the cut-through enforced in Kochen was done without a negotiated cut-through clause.
Yeah, and when that case came out, I think everybody was shocked by that decision, which basically adopted a facts and circumstances test. Now, by the time that had come out, Reliance had a separate court order to deal with cut-throughs, because another way to frame it, the issue is that basically direct payment to an insured by the reinsurer violates the statute, and it violates the court order that issued when liquidation began. So the only way you can get the cut through is if the reinsurance contract itself has the language that expressly allows it, that the reinsurer must assume it as a direct obligation. Effectively, it's an ovation that occurs. And the reinsurer must get informed consent from the insured. Both parties have to want this. So that's basically the process we had in our court order. So post Legion decision, there were two routes, to the court order and try a Legion facts and circumstances test.
So of our $1 billion estate, Keith, I do remember a Med-Mal case that we did intervene and settle specifically with the cut-through clause.
Just because
how are we
we
doing
have
time-wise?
about 5 minutes left, so we want to just turn now to some different ways to wind up estates, and then we can close with your thoughts on some of the current issues.
I actually want to just comment, because we didn't really talk much about offset, which is, quite frankly, a huge issue between receivers and reinsurers. And I think most people here know that mutuality is really what that's all about. Same parties, same capacity, same timing. The issues that come up is when there's a pooling agreement amongst the seeding companies that then can change who technically is the party with the offset, and it works both ways. And there are some premium issues. There's still 5 or 6 states, Pennsylvania being one of them, where you cannot offset premium, which upsets reinsurers. And there's a separate issue that arises where there's a conflict between what the statutory right is and what the contractual right is. And I've had no shortage of reinsurers come to me that says, well, the statute just grants us the right to the offset, and that trumps the contract. And I would say, yeah, but the contract, we have a provision that limits it to this agreement only. And we actually litigated that issue and prevailed on it because the court decided that rights are fixed at the date of liquidation. You didn't have that right then, and the statute doesn't broaden rights that you don't have. And that actually was a nice decision.
And again, from the reinsurer's perspective, this offset right is hugely important. That is, here you have parties in different financial capacity doing business. Well, in Reliance case, we were about the same size. But the whole motivation of the offset statute is to encourage parties of greater financial strength to support the cedent who needs financial support in running the business. And yet, as Keith says, it's kind of a slap in the face that we're obligated to pay the claims in full without diminution, even though we didn't get the premium. So not being able to offset premium is a little irritating. But it's very important that when we cede business to an estate, we're also able to offset those balances against recoveries from losses that were ceded by the estate to the reinsurer. And in many, many estates, this is a very material dollar amount. In Reliance case, again, hundreds of millions. But in a typical estate, it can be 25 to 100% of the claim against the estate can be effectively offset. So this is a very material right to reinsure.
Winding up, I think we covered some of those. We covered the commutation statute in New York. We covered lost portfolios, novation. Novation is a enormous headache for intermediaries and for the parties because you cannot novate a contract without novating all of the individual policies. So you have to have notice and consent to all of the policyholders that currently hold policies under the treaty. So it's not as easy as just signing a single novation agreement. However, if you do sign a single novation agreement and there aren't individual policyholder consent, you can still go ahead with the novation, but there is not finality because those policyholders can either sue the original, the insolvent estate, or the new party that's standing in as the novating, the novatee.
Yeah. To Myra's point, if you're dealing with a portfolio business that has lots of policies, it becomes virtually impossible to get the policyholder's consent on a big portfolio business. But innovation is one exit strategy for a few policies issued to large commercial insurers, but more importantly, there are lots of other exit strategies. Adverse development covers, 100% reinsurance, hopefully schemes like Vermont and Rhode Island, New York 141. So again, in the big picture, liquidation and receivership rehab are statutory structures that states have for financially troubled companies as an exit strategy. They take a fair amount of time, almost always years. In the state, in the example of some estates like Midland, at 25, 30, 40 years. But there are other exit strategies, and our industry is starting to embrace them commercially. We're doing a lot of transactions around the world with exit strategies. And in the U.S., you're seeing far more exit strategies in the last 2 or 3 years than probably we saw in the preceding 50 years.
So some current issues?
David had a
We have-
comment.
Oh, I'm sorry.
The only thing I would say, in the U.S., I think one thing particularly focus on would be the computation of reinsurance. It's usually the largest asset, and I think if you are successful in a program to commute and collect that asset, and you don't have a lot of asset collection left, I think you have a lot of other options to look at what remains, which are the claims, and how to settle them in the most expeditious manner, and then close these things. So I think the commutation of reinsurance, to the extent you can do it, can be very instrumental in trying to close these things.
I think we can go now to the just maybe 3-minute discussion of the current issues.
Yeah, I just want to mention I'm mostly involved on the front end, before companies get to rehabilitation and liquidation. And one of the major changes in the front end is in the credit for reinsurance context, that companies that offshore reinsurers that previously had to post 100% collateral now are entitled, based on their financial strength and a number of other factors, to post less than 100%. And this was fought by a great many seeding companies. They were against this. And one of the reasons they pointed out that they should be 100% collateral posted was in the event they were financially distressed and they needed or that the reinsurer was financially distressed and they needed the comfort of that letter of credit or trust agreement backing up loss reserves. So they lost that fight. There's now reduced collateral in varying degrees. Well, what happens when there is an order of rehabilitation against the seeding company? Are they left trying to, is the receiver left trying to collect less than 100% collateral on offshore reinsurers? And the answer is no, because built into the credit for reinsurance, the new credit for reinsurance statute, is the provision that upon an order of rehabilitation, insolvency, liquidation, 100% collateral must now be posted, which segues into the other current development, which is there has been a tremendous rise in collateralized, fully collateralized covers, where the limit of the reinsurance agreement is now being collateralized by companies, not just offshore companies, but as part of the reinsurance deal, so that those funds are available regardless of insolvency, regardless of where the company is located. They're available in the case of limit losses, which is an enormous benefit to the seeding company, and hence an enormous benefit to the receiver in liquidation. The money is in a fund that the reinsurer, or in some cases a hedge fund with a reinsurer acting on behalf of the hedge fund, cannot draw down without the agreement of the seeding company, or in the case of insolvency, a liquidator.
And from the reinsurance perspective, this change in U.S. state law on reduced collateral is in some respects leveling the playing field, as Lloyd's historically has been allowed to have a U.S. trust fund collateralizing their U.S. obligations, which was set at a value less than 100%. And so a reduced collateral requirement for other reinsurers doing business in the U.S. In some respects was leveling the playing field. But reinsurers would say, we have no problem with pricing and establishing full collateral on negotiated contracts. It's just that collateral obligation gets priced into the transaction.
Exactly. It's a negotiated item.
And that's probably going to be the last comment here, but as a receiver, we were very happy whenever we had collateral because you got paid, and it's the people who didn't have collateral where you struggled mightily to get paid. And I just one additional comment, because you mentioned Lloyd's, is being a multi-beneficiary trust, and there are other multi-beneficiary trusts. I always viewed that as illusory because of the hoops you have to go through to actually get to that money. It takes years, and you have to have a final unappealable judgment on the claim. So you got to go through a whole litigation process just to be able to go make that presentment. And the point of having the collateral is, I paid the loss. I'm looking for reimbursement. I want the money now, not a couple years from now after an expensive process. And so that's another point.
Yeah, and companies are now willing to pay for that assurance that they can access that capital.
Okay, thanks very much to the panel.
Thank you.